guys, I am so sorry. I've had connection issues. I tried my phone, computer, and finally had to reboot and come back. But Timony is here. She's been waiting forever for me to come on. So without further ado, I'm going to bring up Attorney Temani Adams. Here she is. I am so sorry, Tiffany. Oh my God. It was just like the computer from, I don't know what happened. But thank you for your patience. I appreciate you.
Oh, no problem. I wasn't doing anything special, just working.
Oh, just working? Okay. All right. Thank you so much for coming back. I'm excited. I'm excited to hear from you. I know everybody in the chat is waiting, patiently waiting. Let me say hello to some of the folks in the chat. You know how to look at the chat, right? If you go on the side, you'll see the side that says comments. You can click there and see the folks, what they're saying.
Oh, okay.
You see it?
Yes, I see it.
Okay. All right, guys. You guys, I don't need an introduction because you've been here before. All right. Hey Linda. Hey Jackie. Hello Ashley. Hello Teresa. Rob. Hello. Kimberly. Linda. Let's see. Miss Green Eyes. Trissy. Let's see who else. Who else is saying hello to us in the chat? All right, Trissy. We have Trissy. All right. Without further ado, let's get started. Hey Tijuana. Let's see. Black Beauty's in the house. Okay, we have Black Beauty. We have Tina. We have, let's see, that's it. Skin Tight. Hello. All right. Vivian, Henny Hen. All right. So Mahogany and Bree. Hey, Mike Crafter. Hello. How are you doing? All right, Tim. I'm ready. I'm ready. I don't know where we're gonna start with. Let's start with the appeal process. Okay. Since we last talked, how was your vacation anyway? How was your vacation?
It was wonderful. It was like amazing. It
You
was.
gonna go back?
Of course.
When did you get back?
The end of August.
Yeah. Okay. So since you've been gone, you know there was another trial. And in this trial, out of the 13 counts that Mr. Kelly had, 7 of them was a win. And his co-defendants was a total win. So that 98% comes down to what, 97 now?
Well, first of all, that statistic is not accurate. So
okay.
They say they have a 98% conviction rate. So the bulk of the cases that they have end up pleading. So if your case pleads, so that 98% is plea agreements, pleas with no agreement, and guilties at trial. So it's a combination. It's just like, it's not just 98% at trial. No, it's a bunch of plea agreements.
Okay. So as far as trial, do you know what the percentage is?
No, I don't know what the percentage is because it's really hard to get that data. And then another thing is, one thing that they do, and I've had this happen on my first federal trial, like when they know like there's a chance they may lose, they will try to give your client the deal of the century, like the deal of the century. So the client is like, oh, this sounds pretty good. Like, you know, it may take it. So they have they'll take that deal. It'll be a plea agreement, which of course is a conviction.
Okay. All right. So they got their numbers by cheating, as I said before. They cheat. But anyway, so the last time we talked, there has been a trial. There's been the overall was, I believe you did say if it's some sort of a win, right?
Yeah, it's definitely a sort of a win, because what that does is once you get into certain things, and they kind of reference this in some of the documents you sent me, you can, like they said, okay, well, he was found not guilty on these counts. So, you know, if this had have changed, then he could have been found not guilty on additional counts.
Okay. So I don't know where to begin. There's so much stuff that I sent off to you. Would you like to start? Where would you like to start at?
Well, first, I guess the actual trial, because like the headlines were like so crazy, like watching the trial, and you guys could go into the courtrooms. That was very different from New York.
It was, yeah, because we got a chance to be inside the courtroom. We didn't go in off, the over, what do you call it? What is
Overflow.
that? Overflow. We sat inside the courtroom. It was limited, but we were in there, and it felt really good to be inside and seeing the whole thing right there. And then we got a chance to see the jury. Last time we didn't get a chance to see the jury, so we got a chance to see them nodding heads, and I kept my eyes on the jury throughout the whole trial. As far as the trial itself, I think it was fantastic. I think the attorneys did a fantastic job. A lot of things came out, like they found inconsistency with the main witnesses, like the two guys, and I mean, only one of them seemed credible. That was Keith Morrell. He was more credible than the other ones. And everybody else was like, lie, 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 liar, liar, liar. So that's the way it was in that one. So, yeah, so it was interesting. It was very interesting.
Gotcha.
Now, I do have the beginning for you. With your expertise and everything that has happened, we're going to talk about the state trial. One of the victims, accuser, she's part of the state trial. She's recently posted that she got that Kim Foxx was going to drop the case, the state case, right? And it had not happened. It went to a hearing, and they're asking for an additional 30 days.
Okay.
So, what do you think about that? I mean, do you think that it's a possibility that everything's going to be dropped, or some things, or
Okay,
are they
so
playing games?
with state cases and federal cases, there's big differences because states have different laws and they can't do a lot of the things that are done in the federal system. Like in the federal system, most of the time, the judges are what we call prosecutors on the bench, meaning they're pro-government. So it's really hard to get things done. Now, in state courts, things are a lot more relaxed, and you have a different pool of jurors, even though like they're still in the same general area. State court jurors tend to be like a lot more liberal, and have a better connection with the actual defendant. So especially in Cook County, like they're going to get a ton of brown potential jurors. So when I always say representation matters. So with that being said, if you have a ton of brown jurors who have a lot more knowledge about what has happened, and are probably a lot more hip and savvy as to what they've seen online and so on and so forth about these young ladies, they may have an uphill battle. And with that being said, in the grand scheme of things, he's been convicted in New York. He's been convicted in Illinois, both in federal courts. It's just like, why are we potentially even using county resources to try him again? Because it almost doesn't make sense. Because if he's got the conviction, you guys are going to bring him back to Chicago for what? Because one thing that is happening is these victims or witnesses, like they're having all types of issues after they're testifying. So a lot of them are just like, no, I don't want to come back. I don't want to deal with this again. I'm being dragged through the mud. And so that creates another issue for the state prosecutors, because you're going to have a situation when you have witnesses that you are calling that are hostile to you because they don't want to testify. Plus, another thing is a lot more evidence can come in state court versus federal court. So in federal court, judges have these hard line rules about what they can and cannot do, so on and so forth. At the state level, you can easily get additional information, and because the laws and the standards are different. So Cook County may be considering like, hey,
so which one is more difficult?
Federal court, as far as from a defense perspective, federal court is more difficult because of the judges, because of the rules. And like I said, they already have 2 federal convictions.
So it's a lot of rules that they have.
Yeah, definitely. There are a lot of different rules. I think Cook County should probably save their tax dollars and just go ahead and dismiss it because
okay. Now, as far as the appeal process, I did send you the information on the appeal. I mean, the Rule 29 and Rule 33 for the Chicago, Illinois, the state case for Chicago. Did you read some of those, the 29 and the 33? And what did you think about those? What did you think about them?
So I think her Rule 29 motion was a very good motion. It was good. She did a good job on that. The Rule 33 motion, I get it. Because I talked about this after the New York case, which is a Rule 29 motion and a Rule 33 motion. Those both are standard motions you file after your client was found guilty. But her Rule 29 motion really has like some meat to it and like a good grounds for her to win. Judges, let me just say, they aren't going to want to grant this, but her Rule 29 motion, it was really good. Now, the Rule 33 motion, the expert lied about how much time he'd spent and how much he was paid. Yeah, he lied, but I don't think that's going to get him a new trial. But what I do think is, because when a person is found guilty in the federal system, you can do a motion for new trial based on new evidence up to 3 years after the conviction, unless the rule has changed. And I doubt it has. So, as I said with the New York case, they have up to 3 years to gather new evidence. And there's a good chance that they will, or that new evidence will come out. But just saying that he lied about his pay, the next step in that analysis is, okay, well, how harmful was that lie to Mr. Kelly? How prejudicial was it? How did it affect his rights? Would the jury have done something different if they knew he was paid more?
But isn't it because one of the parts she said was that his testimony about him spending so much time on that particular case was not true? He said he did 6.5, but in actuality, he only did 2 hours of research and trying to get information regarding, because I know his testimony stated that the reason why they didn't come out in the beginning is XYZ, but now since he really didn't spend much time on it, does it weigh heavily on that?
See, I think the thing is, I can see where she was going with it, but she didn't really flush it out, if that makes sense. Like, she gave the argument, but she didn't flush it out well. So yeah, I definitely understand, like, hey, you know what? He said they didn't come out because of these reasons, but he didn't spend an adequate amount of time, when preparing. So no, I definitely get it. I think she could have just added a little bit more to it, a little bit more as far as like an analysis and going into more detail as to why, his false statement was prejudicial to Mr. Kelly, because that's what it's going to come down to is, did it prejudice him?
Okay. Now, also, I did send you the secret jury.
The grand jury. Yeah, I was like, how did she get this?
Somebody made a mistake, and I happened to be in the system and swiped it before they closed it back down.
Gotcha. So I was like, grand jury testimony is very hard to get. Very hard to get. Like I have some from a couple of cases, but like even my other like lawyer friends like in New York, they like when I tell them like on cases, I got the grand jury testimony, they're like, hey, you got the grand jury testimony? How did you do that? So yeah, that's not I was reading it, but I was like, what? Like, how did she get this?
You know I'm good, right? I'm good.
Yes, but yes, I did see it and I did read it.
So what's your opinion on that one?
Like, whoa. Like, whoa. And because I'm reading it and then like going through all the things, and I think that and it ties into the Rule 29 motion. And I was like, oh, that's why I said the Rule 29 motion, like she has more action with that than the Rule 33 motion. So I was reading it and I was just like, OMG, like, you know, she has 2 immunity agreements to testify, the age situation, the different threesomes, the lie about the tape. I was just like, whoa. And I think that, well, in the federal system, well, even in the legal system in the US, we have this saying, which is you can indict a ham sandwich, like you can. But for her to provide like false information to the grand jury, my thought process is like on the stand would have been like impeach her. Because when it came down to it, like that was important. And for her to say, and one thing I realized is like she had a lawyer at the grand jury, and you can have that. That's perfectly fine. But the fact that she didn't add anything to her testimony, they just read in her statement and that was it. And the fact that the grand jury didn't ask any questions, because I've had cases where the grand jury does ask questions because they want more information. But it seemed like she was just sticking to her statement and wasn't going to add anything else.
What about the part where the jury did ask about Aaliyah, and they asked why wasn't it part of the case, and if not, why did they bring it in? Why were they bringing Aaliyah's in?
And that's what I'm like. It's insane. So I think like the case in general, like he was found not guilty on some counts, guilty on the other ones. So when I was reading her testimony and reviewing the Rule 29 motion, it was just kind of like, OMG, because I'm pretty sure like their motions practice during like the motions they filed were, you know, pretty intense. But even just with her being such like a main witness, I feel like that's a big thing. And then I think like she did so much like throughout, just from when the Surviving R. Kelly documentary came out. She was doing interviews everywhere. And to know that she got a lot of money from him, and then she gets money from all these other interviews and so on and so forth. It is like,
don't forget about the book. Don't forget about the book. She got money from the book too.
And I'm just like, whoa. So it's just like, okay, why are you doing this? Because it seems like the financial gain is the biggest thing. Like, this is a gravy train for these women. Like, this is a gravy train. And one thing I was thinking when I was reading, because she said she went to this lawyer and made this video and was crying, said she never had sex with the LaFair person, and so on and so forth. I was like, okay, I know for sure, like, lawyer 101, like there was an agreement to say, okay, if you accept this money, you can't do X, Y, and Z. You can't talk about it, so on and so forth. And so many of these women have. And I'm like, why didn't he sue them for his money back?
Well, that's a good question. Can he sue now? Or
yeah, he can, because what's the girl's name? Geronda Pace? Remember, she broke her agreement and she has to pay him back. Yeah, so I'm pretty sure they definitely all can, because even if they didn't have a confidentiality agreement, to say, like, sometimes in agreements you can say, okay, if you break the agreement, you have to pay back X, Y, and Z, the money. Or you can, if it's just a contract that says, hey, this is what we're doing. Any breach, instead of automatically forfeiting, we have the ability to come back and sue you, and for the money we paid and for attorney's fees.
Yeah.
So yeah, I'm just like, what? I think and I remember in the New York trial, they were saying something, this was at sentencing, about like his finances and so on and so forth, but also like basically his circle, his inner circle had just taken advantage of him, like to a very large point. Like, I think one person testified, like when they had met him, like he didn't even know like where his royalties were going. He didn't know, all these things. And I'm just like, what? Because why didn't he have a lawyer, like on staff the entire time to nip these types of things in the bud?
But remember, well, in the Chicago case, the manager said that the lawyer is the one suggested to pay them. It seemed like everybody was getting a piece of the action during that time. The other lawyer, I think Susan Logan, she was making deals with individuals that was bringing these individuals, these women to her to have settlements as well. And then his lawyer was just like, pay it's better because it messes up your reputation, blah, 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 blah. Just pay them. You know what I mean? So, I mean, it was crazy.
He just paid. Yeah. It's just like, whoa, like who, like, obviously he had like really bad advisors. That's the first thing. That's just pretty much it. Cause how do you not know, where your royalties are going? So I think he had like bad management, bad lawyers, like basically a team of people who knew of his disability and just took advantage of that.
Yeah. All right. Oh, whew. It's a lot. I'm gonna put in the chat. I think I saw Spit and Fire. Spit and Fire, did you want to come up? So are you ready to ask, for questions in the group, or?
Yeah, let's go.
All right, let's do this, y'all. Let's get the questions going.
And so one thing I will also add is, like, in the federal system, the appeals process is not wonderful because you don't get that many chances to fix the error. And it's just unfortunate for the people who are charged with crimes. So you have your trial, then you appeal to your circuit. And if you don't win at your circuit, then your only option is going to the Supreme Court.
Oh, no. Okay. Now, question in regards to that, because Jennifer and Ashley just recently asked for an extension because they want to include the restitution part in that. So, how do you think that will work out as far as getting the extension? Do you think they give it, or is it?
Oh yeah. So in appeals courts, like, giving extensions is very common, especially if it's like your first or second one. They're very common. Okay. They're very, very common. So that's not really a big deal. And also, so in regards to the appeals process, let's just say, you go to your circuit, you try to go to the Supreme Court, and the Supreme Court doesn't take your case. Then you're screwed unless there's some type of new law that's retroactive, or there's some type of new evidence, like I said, within the 3 years, so on and so forth. But it's the federal appeal system, the federal criminal system is just really hard on people.
Oh, wow. Okay.
Hello.
Right. Hey,
Hello.
this is Spit and Fire. Spit and Fire. This is Temani Adams, Attorney Temani Adams.
How are you?
I'm good. How are you?
I am wonderful. You giving such good knowledge, and I appreciate it. I appreciate it from the chat. I mean, you just light up the whole screen and with all the knowledge. It's good to see a sister that's knowledgeable and teaching us what's going on with the law. But I have a question. So you read what, I guess Sylvia must have sent you some things, right?
Yes.
Okay. What do you take as if you are a lawyer? on this particular case, and you know what you know from what Sylvia has sent you, what can you tell us or your personal thought now that you know what you know that you probably didn't know prior to her sending you the documents that she sent you?
So I think my biggest takeaway is the devil's in the details. So when in reviewing Lisa Van Allen's grand jury testimony, they more than likely they had that before she testified. So with her, my thing would have been impeach, 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 impeach. Because, and basically that's saying, hey, you made this statement at this time. Now you're making a different statement. Which one do we believe? So that's the main thing is impeach, 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 impeach. So with regards to her. And then in regards to the Rule 29 motion, it's a really good motion, and it kind of goes like towards something deep in the details, like deep in the jury instructions and deep in the law. And so tailoring an argument specifically just towards that. So say, for instance, one of the things she talked about was there was no inducement for one of the young ladies or for one of the victims. Well, there should have been a lot of questioning of, hey, did he induce you? How did he induce you? If so, because I think a lot of times in court, lawyers don't want to ask those direct questions, but those direct questions go with the jury instructions. So why not make it easy for the jury?
Right. That's a good idea. That's good. That's a good strategy. I would have did that too, probably, if I was a lawyer and knew what I was doing. No, I'm just joking. But one last thing before I get out, because I'm gonna let somebody else come out. What do you think about all of these? What they have? Immunities. All of these immunities is crazy. They don't went crazy on immunities. And Section 8 for testimony. Yeah, I mean, I know you have to have read that part.
So I think that the government often says, well, we have to make deals with bad people to capture bigger bad people. And so that's like their excuse. But it's just like, hold on, wait a minute. Like, where do we draw the line? Like at some point, like we can't have every criminal coming in here.
That's what I was saying. Like everybody, all your witnesses were bad people. Like everybody in this case, from when we was blogging about it, everyone in this case, I just find it so interesting that everyone has immunity. So I understand like they give deals to bad people to catch bigger bad, but everyone, like everybody, like this is insanely. This is just, I don't know. I just thought that was something funny. And I wanted to see another lawyer's perspective on that. I just knew it couldn't have been us that are non-lawyers, but lawyers had to have. So what do you take away from this case since you now read what you read prior to knowing what you knew, before you read it?
So I think that, in the federal system, with any, like a case where you're going to trial, you have to have a team, like your trial team, and a team that like knows the case very well, because the government often engages in pure shenanigans, and they do this to kind of throw you off in trial, like so that you may miss something or overlook something. So when I was reading everything, my thought process was like the importance of, like, you have to have your team, like a really, really good team, so that if you fall short on something, hey, you got somebody else to remind you, hey, don't forget to ask this, or don't forget about X, Y, and Z. But I definitely understand, like, when you're in trial, things are chaotic, but to know that they wanted him so badly, that it's just like, we're going to make deals with the devil to try to get him. And it's just, at the end of the day, it's almost like, for what? Because he was already convicted in New York. And I totally get it, trying him in 2 different jurisdictions. That way, if he gets acquitted on appeal or get a new trial on appeal, they still have a conviction in the other jurisdiction. But I feel like the Chicago case just shouldn't have came. Like, it shouldn't have happened.
Wow.
But
Okay.
it looks like he's going to get off on both because the way the Chicago one, it was like you got all these liars getting up there and you still get a conviction with liars?
The Chicago case, I feel like the Chicago case shouldn't have come. One, because he beat the case at the state level. That's the first thing. But again, they can try him federally, and I totally understand that. But what it does is it basically like creates more distrust for people in the criminal justice system. Because it's like, okay, well, he won at this level, whether you think he did it or not, he won. So do you believe in the justice system or not? Why are you going to try him again at the federal level? And obviously because they believe they could get a conviction. But people already have a distrust of the legal system. So it makes it people feel like, hey, well, if I win once, then you guys can come after me again, just a different way. And that's what happened.
Yeah,
I know. Okay.
I was just thinking, like, at the federal level, I was thinking that they was bringing those charges up because of the obstruction that they initially tried to charge him with. You know what I mean? Because there was a press conference going around about he obstructed justice and he purchased his 2008 acquittal and all these type of things, and that was supposed to be the reason of the feds coming in trying to try him again. But the thing of it is that even in this particular last case, I didn't think he get found guilty on the obstruction.
He did not.
He was acquitted on that. So it's like you going back to the child pornography, which they got a conviction on the federal level, but they only really brought that case back up in addition to with the obstruction. And so now it's like it seems like it's a big mess now. More so than anything.
I definitely agree. Like to say, okay, well, he obstructed justice and he bought this case, this 2008 case. You guys waited 11 years to say this. You guys had plenty of time to say this before, and you guys had plenty of time to gather this information. This wasn't like, none of this was anything new. This is the Cook County at the state level, and then at the federal level, like this is information that was already available to all of you all, and it didn't come about until the documentary came out to say, okay, what else can we do? Like, but you all knew this the entire time, and it was not an issue until this documentary came out. This wasn't new information. This was stuff they already knew.
Yeah. And then they turn around the two tapes that supposedly that they saw, there were no underage on those tapes.
And see, and that's the second part with their judgment for acquittal, because it's like her saying, this tape thing is just a hot ass mess. Like, it's just a hot mess. Because Lisa Van Allen was saying, okay, the tape she saw that she took was the one with her, and that she kept going through tapes to find the one with her, and then the one that was turned over to the government was like in a different room and so on, and was with someone else. And it's just like, hold on, what are we talking about at this point? And then we're talking about women who we may not even know who they are. So we're just saying the tape with this woman, like the tape. Well, which tape and who was the woman in it? Has she been identified? Was she underage? If not, it's not relevant. So why are we talking about it? Mm-hmm. It's messy.
It is really messy. It's really messy because I just didn't understand about the tape. I mean, it was like we have so many tapes, then we don't have that many tapes. Then this is the same tape that the state had that acquitted them, but now it come up in a federal case, and now there's some audio to it, but it wasn't audio with the original tape that was shown back in 2008. It's just a whole mess of and I don't understand why any judge will even sit up there and just allow that heap of all in their courtroom with all this inconsistencies and everything else that they got going on. But what gets me, Ms. Adams, what gets me is the fact that every time Jennifer Bongine put in a motion for her client, it's always something that the government messed up or they found somebody lying on that side. And I'm like, this has got to be the biggest miscarriage of justice I've ever read, covered, did a story about on anything. I don't know what to do, but I just want to say thank you for answering my questions and everything else. Thank you, Sylvia, for having me come up here. I'm gonna let if somebody else come and give Miss Adams time. Thank you again.
No problem.
You're welcome. I do have a question in regard to the young lady who said at first that wasn't her on the tape, right? She told the police officer then. Her mama told it wasn't her. They went defacts, it wasn't her. Grand jury, it wasn't her. All of a sudden, she's getting Section A. Now it's her.
Yeah. Well, I'm like, my first thought is like, what did you do with the money to where now you won't say change? Like, how do we get to this point? But no, it's just, I think that sometimes, and I do this a lot when I have to, is I got to be an asshole in court. Like, and that's just what it, like, and you got to call it what it is, right? So say, for instance, this wasn't her. Then how old is the girl now?
42, I think. 38 or 42?
I think she's
38, 42.
All right. And she was allegedly 14 when she made the tape, when they made the tape. So that's a whole lot of time. So from 14 to 42, that's 28 years. So I would honestly like create I have a tech guy who does my trials with me, and we'll change a PowerPoint right in the middle of the trial. And I'm like, okay, you know the difference, at age 14, did you know the difference between a lie and the truth? She'd say yes. And you knew it at age 15 and you know it now. She'd say, yeah. And it's like, and I say, well, if you knew that this wasn't true, why did you say it? And she'll say whatever she said. And then I said, well, why did you come forward now? And she may say, well, because of my conscience or whatever, so on and so forth. And I'll say, well, let's say at age 18, your conscience wouldn't bother you. What about at 19? Maybe 22? What about 27? And just go through the years. Like, if your conscience was bothering you that bad to where you came out all of a sudden, why didn't it happen in all these other years? Like, all these other years. Like, if she may say, well, I never had the opportunity. Well, did you ever get a parking? Did you ever get a ticket, get pulled over? Well, you saw an officer when you got pulled over. Why you didn't tell him then? You know what I mean? Like, you had several, like, and just going, and like, you had all these opportunities, and you never did. But now you fallen on hard times, and you need a little help. And help in this case came in the form of a Section 8 housing voucher. And now we would go into like what Section 8 is. And you need a place to stay, don't you? Because of X, Y, and Z. And the government told you they'd help you out. And just go from there. Because to say from 14 to 42, like you had 28 years for your conscience to tell the world. Like, and I'd be like, well, how far is the nearest police station from your house? You could have walked there. Like, it's just so many ways to do it. Like, this is something, and so you do it in that way to where the jury be like, you know what, she's right. Like, you did have a lot of opportunities. You could have easily done this over the years.
Yeah. Okay, let's see what question we have. One, how many people were making money? It was a scheme from all of those white people. Sorry, but who made all of the money? Is that a question?
I think it is. I think it's a question and a statement.
Okay. So
I think the people who made the money were the lawyers. The lawyer Susan, who had the meal basically to have the girls come in to do the settlements, because I'm pretty sure she was taking at least 30% of the money. And she had to do very little work to get it done, to get it approved. Then, of course, his lawyers and his managers. That's who made the money.
So they were all getting a dip of it.
Yeah,
except him.
Except him. That's why I say he had really, really bad advisors. Everybody was getting paid except for him. As long as he kept singing and making money, everybody was fine with it because they knew they was all going to make money.
That's messed up. Okay, what do you think about Jane receiving money and gifts to testify? We just talked about that. No, we didn't. Did we?
I think anybody receiving money and gifts to testify is wrong. That's just what it is. If you aren't testifying on your own accord, that's inappropriate. Let's just say if I'm coming from Texas to New York and they cover my flight for testimony, that's fine because I got to get there. But to say, oh, I'm going to give you a benefit to testify, that's inappropriate on every level.
So why is the federal government allowing it?
So the government does this thing where they create a story. And this is like with trials in general. Like we tell them, we present our cases in like a story format, right? So you have to have your story that you're presenting and it has to make sense. So the government has their story and they're going to stick to it because they're not going to say they were wrong about anything. So they have their story and they only want evidence and witnesses that support their story. If they can get evidence and witnesses that support their story, that's what they're going to go with and screw anything else outside of that. If it doesn't fit their story, it's like, let's attack that. But no, if it fits their story, they're going to do whatever it is to make sure that they can secure that witness and have that witness testify to support their theory of the case.
Even if they're wrong.
Even if they're wrong. So say, for instance, like she's in the Rule 33 motion, she's saying, well, he lied about the amount of he was charging and the number of hours he worked. The government knew that right then when he testified. They could have and should have corrected it right then, but they didn't because then they could have crossed him on his credibility. And then that would have hurt their theory of the case.
Okay.
Like that's insane. Like that they knew they like we're sitting right here and this man's testifying and you know he's lying and you just let it fly and let it go to the jury.
So then that's not fair to a person that's sitting there. Their life is at the stake of this trial and you're allowing people to lie to get a conviction. That's not fair and that's not right.
Oh, I definitely agree. All
right, next question is that a form of double jeopardy though?
No. So charging someone at the state level and the federal level for the same crime, that's not double jeopardy because these are two separate sovereignties. You can charge someone at the state level and the federal level.
Okay. Did he supposedly commit any of these situations in New York? If not, why was he tried there? I think it was because of Faith Rogers, because she said that they had sex in New York or something like that.
Mm-hmm.
Yeah. Okay. Daddy Lolo says, ask her what about video 1 already being ruled a fake in 2008, but a forensic specialist, but now it's not a fake because Rashonda said it was not a fake. How can that be?
Okay. So again, the 2008 case was a state case. So they have different rules that apply. And the rules in the federal system are totally different, not necessarily the rules of evidence. They're always similar. But one, I don't know if he had a specialist in the Illinois case, the federal case or not.
No, he didn't. They said that her testifying it was her is enough. They didn't need to do that, and they didn't need to do a chain of custody or something like that, they said.
Yeah, but you do, because you still need to be able to authenticate it. She may say, "Oh yes," because especially technology has advanced so much since back then. So even if she's saying, "Yes, this is me," okay, that's fine. But there's other things in the video that can and cannot be authenticated or edited. So say for instance, they were saying, I think they were in the log room or the cabin room and so on and so forth. No, even if she's saying, yes, this is me, okay, can you authenticate everything else in the video to prove that it was not edited?
That's a good one. That's a good one. Yeah.
So that's something that I don't know if they even like went deep into the authentication of the video. Yes, she said it's her, but we don't know what else could have been edited in the videos.
And question, can they bring the fact that Michael Avenatti is the one that bought the tape, because he was the attorney for Freeman, and Freeman gave him the tape, and he's a convicted felon, so why couldn't they bring that up more in the case?
So one, I definitely would have like flushed that out a million times, because saying that previously the tape wasn't found to be authentic, and then now it's authentic, and then now we have this tape that magically appeared from a convicted felon, this lawyer who turned out to be like a shyster. It's like, okay, and then like the sound issues. All right, well, she's saying this is her, but yeah, what else was added? Like, what else was added?
Found, and she's saying about her vagina age and all. It was crazy. It was when I listened to it, because I was in court. When I listened, I was like, this seems like role play to me. It seems like somebody's like pushing this is who would say that? And you're 14 years old. Why would you be calling your private part that age at 14?
Exactly. Exactly. So I think, and I talked about this with the New York case, like people, a lot of attorneys in dealing with cases with sex are scared to ask certain questions. You know what I mean? Because they're uncomfortable asking. And if they're uncomfortable asking, guess what? The jury can tell. But you have to make yourself comfortable to get your point out. You know what I mean? So to be like, hey, and also representation matters, because I remember in the grand jury testimony, she was saying he told her to call him daddy. And I was thinking about that. And I was like, well, shit, like a whole lot of people call their man daddy. Like, let's just be for real. And to be able to say that confidently to a jury, that doesn't mean that he was a grown man having sex with someone that could have been his child. It means like, hey, this may be something that he is into, and that's not a crime.
Yeah. Okay. All right. Next question says, Miss Adam, what happened to with the tape not being original?
I know who this guy is, because he called me. I was not upset. I was not upset. He called.
Okay, let her know I'm the guy that called her a month ago and she sounded upset.
I wasn't upset. It was just weird. I was like, oh, he could have sent me an email. That would have been easier. But he said he thought he was going to get my voicemail.
Oh, and you answered?
And I answered.
Okay, wasn't he charged with a RICO in New York, and the jury in Illinois found him, McDavid and Brown were not an organization?
So I don't know about that, but even if that is true, what that does is pretty much makes people more frustrated, because the new Illinois case is not going to have any bearing on what is found in the New York case.
Oh, really?
Yeah. In some ways, like as far as some ways. So because the organization issue for the RICO that was in New York versus the allegations about if there were allegations of organization in Illinois, what they would say is this is two different operations.
But they're saying that he, because he's the only one that was charged with the RICO, right? So with them showing that there was no organized crime, like bullying the jury and stuff like that, because they claimed that he did that, bought the Illinois, the Chicago case. So now it's proven that there was no RICO. So would that affect it, or?
No, because one thing appeals courts love to say is we are not going to disrupt the jury's verdict. If that's what the jury believed, so on and so forth. Like I said, the appeals process is brutal. They nitpick to do everything they can not to overturn a conviction or give someone a second bite at the apple. So the case in Illinois and the case in New York and the rulings, they aren't going to come together because they're not a part of the same jurisdiction. So I think his only chance of getting those two cases tied together is if he gets both of those two cases to the Supreme Court.
Oh, okay. Okay, I got you. All right. Let's see. Okay. I was trying to get down to the next question.
Okay.
Okay, here's Linda's question. She says, why were they allowed to say these things without any evidence to support their claims?
Oh, that happens all the time. So it's sad, but this is very true. In America, we have, you're innocent until you're proven guilty. That's what they say. Realistically, no, you're guilty until you prove yourself innocent. So people often make testimony in court with no evidence, and then the jury has to just weigh the credibility of their testimony.
With liars.
Yeah. So once I had a case where the officer stopped my client, him and his passenger, so on and so forth. And I knew that the cop was lying about something. So when I get to cross-examination, my first question is, Officer so-and-so, are you a lying liar that lies? He's like, no. Well, let's talk about X, Y, and Z. Like, I'm setting the tone because let me show you where this is going. Like, I'm going straight into what you lied about in the beginning because you just said you're not a liar. Well, let's talk about all these times that you lied, and I can prove you lied. So in those situations, like, you really have to just go for it.
Wow. Okay, Ms. Guided says, do you think anything will be done about the prosecutor that was meeting with Jane off the record and from her personal email?
I saw that. Something definitely does need to be done. That was completely inappropriate. There was, what was that guy's name? Jeffrey Epstein. So in the Jeffrey Epstein case, the prosecutors were also contacting him on personal email, after hours, all types of stuff. This was on his Florida case. So Jeffrey Epstein was charged at the state level in Florida, but they were going to charge him federally as well. So the federal prosecutors are emailing him, all this types of stuff, sending their personal information to him, to his lawyers, to contact them, like after hours, to have like all these secret discussions. And nothing ever happened to them. They gave Jeffrey Epstein this sweetheart deal.
Mm-hmm.
The prosecutor ended up later going to work for Trump. When he got elected, I think with the Department of Labor or something like that, as an advisor or something. And And then they had the documentary for Epstein, and it came back out about this is the prosecutor who gave this sweetheart deal and was communicating with his lawyers, through personal non-government emails. What happened is he ended up resigning from his position, but as far as his duties as a prosecutor and what he did, no, that did nothing to him. But I think in this situation, it's a little bit different. And he may have more action on appeal because they weren't talking to her lawyers. They were having direct communication with her.
Yeah.
So I think that is a good option for appeal. I definitely think that they should have had a separate hearing about that to go deeper into what happened.
Oh, okay. Ms. Guided said, okay, that we answered that question already. Let's see the next one. Okay, is that prosecutorial misconduct?
Yes, it is. It definitely is. So another thing is this. So, and you guys don't know this because you guys aren't lawyers. So there's the bar or judges or whatever will quickly come after a defense attorney for doing something wrong. But for a prosecutor, they're going to give them a million chances and try to carve out some reason why what they did wasn't as bad as what they did.
But she's gone now, right?
Mm-hmm.
She's gone.
Yeah, but the thing is, it still happened. So, and they still presented, this information. So it's no, because this person may have coerced her or, use their influence to induce her, as they say R. Kelly did in the Illinois case. And there should have been an inquiry about that. I think honestly at that point, his team was just beat down through everything else.
What do you think about Jim Derogatis?
Who was that?
That was the guy who wrote the book, the one who's been following R. Kelly.
The reporter guy.
Yeah, the reporter guy. He came into court and he pleaded the fifth again. So he didn't have to testify.
So, and I think him, and let me just say, I think the documentary was, and a lot of the other interviews that the ladies did, they were very, very, I don't know if they consider themselves journalists or not, but it was very irresponsible journalism. It was, because there was a lot of things that were not true that came out. And we've seen that through them, pleading the fifth and so on and so on and so on and so forth in court. I think at that time, them doing interviews and all this good stuff, that was the thing to do, to promote their book, their brand, or whatever it is. But these journalists, or whatever they are, just taking the interview and letting these people say things versus saying, okay, hold on, let me fact check this myself. And presenting both sides, not just one side that they liked.
And that's what Derogatis is doing, because he had a motive. He was trying to come after R. Kelly, Mr. Kelly. Okay, Bopa says, how was there many witnesses on the stand that states they have extorted this man, and yet nothing was accountable, nor was it proven they were held hostage or was taken care of? It was proven they were of age.
So I think, one, again, it goes back to his horrible advisors. And I think, the moment any of them broke their agreement, their confidentiality agreement, he should have sued them. That way, that could have been another talking point in court. So let's just say he's testifying, a woman is testifying and saying all these things that happened, and you bring up the amount of money that she's gotten, and that now he's suing her for her money back. That goes to motive. Why are you now testifying? Oh, because now he's suing you. So then it's as a juror, okay, well, why he's suing her? And why that's not over yet. You like, we want to see what's happening with that case. There is, I think a lot of times people, lawyers do things, have hearings, or have a certain line of questioning because they're saying, okay, I want to know this. But a lot of times I always say it's chess, not checkers. So there's, I have a murder case right now on my desk. So we had a hearing last week. They were holding my client's car. He wants his car back.
Mm-hmm.
I completely understand that. But it's a self-defense murder. And so the judge, she ends up saying she's not going to get the car back until after trial. I didn't give a fuck about whether or not she gave that car back. What I cared about was I was able to get the officer on the stand and say that the victim in my case, who my client shot, was actually assaulting my client. And he testified, oh yeah, because he was punching your client. So I already have it on record that my client was defending himself.
Mm-hmm.
I could care less about the car. I cared about getting it on the record that this guy was actually assaulting my client. So I think it's more of like thinking 10 steps ahead with your line of questioning and what you can get out of it.
Mm-hmm. Mm-hmm. All right. Patrick asks, was there any of his rights violated? Do you believe that R. Kelly's rights was violated?
I think a lot of his rights were violated. And I think that just in the grand scheme of things, like his team is just overwhelmed with so many things. Like, say, for instance, with I think the BOP, like releasing his personal information and some of his communications, like that's a violation. Where is this person? Like, what were the ramifications of that? Was this person fired? So on and so forth. Also, I think about numerous other things. I think like I said, them charging the Chicago case, they legally could do it, but I don't think that was an appropriate thing to do. I think the government was just trying to hop on the train after the documentary to say, oh, well, we did something.
Okay. Do you think anything will be done about that prosecutor that met with Jane off the record? Okay, so we answered that. It seems like the same questions are coming back up. Hold on. Okay. It says here, and why weren't Susan Logan forced to get on the stand since she was the main person who helped extort this man?
Because they didn't call her as a witness. That's it. They didn't call her as a witness. And I think that, and I was really disappointed in his defense in the New York case, because they barely called any witnesses when there were so many witnesses that could have been called. Just in the grand scheme of things, like, again, like Susan Logan, they could have gladly called her as a witness, because it asked her, okay, did you feel like these young ladies were credible when they came in and brought you this information, or were you just concerned with your cut that you were going to get? Because if I'm getting, let's just say, it's $1 million, he's going to pay someone $1 million, and she's getting 30%. That's $300,000. Yeah, I might, after I've done 10 of these, I'm a millionaire, and on the cool, he may have, and at some point you're like, oh, he may have done it, he may not. Let's just go ahead and push this through so I can get this check. You know what I'm saying? Yeah. Because he don't know. He don't know no better. So, yeah.
It's pretty sad.
It is. Like, the people's level of greed is insane. And especially when you truly believe, like, you're not going to get caught or found out about.
Yeah, it's pretty sad. Wow. All right. The next one is, what is your thought on Kim Fox to announce dismissal of his case, the state case?
Yeah, we talked about this already, but I'll re-answer it. So it's just, it's like, okay, I get it, because she can say, okay, well, he didn't get away. I didn't let him get away. He's already been convicted on 2 other trials. There's no point in, wasting Cook County resources on a 3rd trial. That's easy to say. But like I said, also, I don't think with all of the mess that has gone on, I don't think that her case would be a slam dunk. I don't.
Good. Yes. Okay. Now, LG wants to know, bottom line, what is his chances on appeal?
He has good chances on appeal for both cases because there's so many grounds on both cases for him to appeal on, and some of them are really, really good. Very, very good. So let's say in New York, the issue of, the prosecutor emailing the young lady is one. It's not a big issue, but it still needs to be brought up. The main issue for the New York case is the RICO, how they charged it. That is like the meat and potatoes of that appeal, is how they charged that case and doing it as a RICO, and was it actually an organization, and what the actual statute was, the purpose for the actual statute. And so in arguing the RICO situation, then you can bring in, okay, well, in Chicago, there was, found no organization, if that's what happened. So I feel like that's the biggest thing, because there's been no instances of the RICO statute being used in the way that it was used for R. Kelly.
They made it up. They just created some way of bringing it in. Okay, let's see. It says, yeah, that's what didn't make sense. Who would scream out and refer to their genital as 14? Okay, we got that one. All right, we did that one. Okay. What is your thoughts about Kim Fox adding the prosecutor adding this additional 30 days?
No, I mean, like I said, on appeal, like you can get plenty of extensions.
No, not this is the state case.
Okay.
They met for the hearing, and then they turned around and said that they needed additional 30 days because they don't have all the documents, like the transcript that they should have had already to read over.
Yeah. No, anytime the state typically asks like for additional time, it's like, we're not ready, and we probably gonna end up in the hot seat. Let's see what we can come up with in the meantime.
Okay. So they're not okay. Let's see. Okay. All right. What do you think about how Kim Fox initially solicited victims where there was no charges?
Oh, it's called the fishing expedition. Because girl, what, like, I completely get that. She saw a documentary and she was outraged and wanted more people to come forward if they had been assaulted. I totally understand that. But at the same time, it is basically saying we want to create something. We want to create a case in response to this documentary to say that we did something because we failed in his original case because we lost. It's just
but you really lost because you didn't prove anything. It shows that the stuff, it was really done the right way the first time.
Yeah, so it's just like I said, appeals courts, I always say that, well, they don't want to disrupt the jury's verdict, but that's essentially what she's doing. She's disrupting the jury's verdict. Cook County already said how they felt about this. And to say, well, let's go find some new girls to have new allegations to see if we can retry him. One, there's statutes of limitations. That's the first thing. And second, you're pretty much going to have the same evidence with the same conflicted witnesses. So who got money and are no longer getting money, you're going to have the same case anyway. So why are you wasting these taxpayer dollars? Cook County has other things to do with their money.
Like help the people. He says, will Kells be able to countersue his so-called victims?
Yes, if they have breached their settlement agreements, yeah, he definitely can sue them.
Okay. All right. What do you think about Jane still being friends and communicating with them, with RK up to recent years?
Yeah, that could have been an amazing line of questioning. an amazing line of questioning at trial, because it goes to, one, you weren't credible. You said it wasn't you for all of these years. And so we go through that analysis. It wasn't you, it wasn't you, it wasn't you. Now, all of a sudden, you need Section 8, and now it's you, because the government's going to get you Section 8. But your conscience was so bad, and it was bothering you so bad, why were you still talking to him? After all these years, if it was so bad and you just couldn't take it no more, so when you had to come forward, and now, but you were still talking to him. That doesn't make sense.
He was paying your rent, helping you out your rent. He kept getting broke, and he kept asking him for money. He helped you out.
Yeah, so it's just like, this is so mean, but like, yeah, my goal would be like, in her situation, to cross her like to the max, to the point she cried.
Yeah, I wish you. Let me stop. Question: do immunity deals ever get taken back? Speaking on when his conviction is overturned and Lion Lisa's testimony is revealed as perjury.
So no, do immunity deals ever get taken back? Yes, they do. In this situation, let's just say his case gets overturned on appeal. Guess what? The government is not going to charge this lady or any of them because it doesn't go with their story.
Oh, okay. All right. What do you think about? We talked about that already. Soliciting. Okay. Can R. Kelly pursue civil, criminal charges against Jim for stalking, harassing, and aiding in his freedom being taken away?
So his freedom being taken away, no. But stalking and harassment, so that's going to depend on the state statute. And so with stalking, there have to be like a certain number of instances where like you've contacted, you've told this person to stay away from you, you may have police report, and so on and so forth. So it'll be a hard burden to prove because I don't think he has that.
What about Susan Logan? Can he sue her for soliciting false accusers for profit?
No, because he was in on it. He kept settling cases.
Oh, so he settled. Okay. Can restitution be put on hold until the appeal is over?
It is on hold. So restitution, and I think they did order taking his money from his commissary account for restitution. That was premature. They should not have done it. It was inappropriate because the conviction is not final. That's the first thing. And the way they did the restitution order, because they did it separate from sentencing. So no, that was completely inappropriate. But the restitution order is not final because the actual conviction is not final.
And when does the actual conviction become final?
So once if he ends up going to the Supreme Court and they won't hear his case, then the appeals court, whatever their ruling is, makes it final.
So that money is just sitting someplace. Then those people, nobody's gonna get that money until everything gets final.
Correct.
Okay. All right.
So that's what's supposed to happen.
Okay. Okay. But they cannot make it happen, or is it?
No. So say for instance, like there's a special unit who deals with restitution in the U.S. Attorney's Office. And so they're supposed to, in this situation, hold it until the conviction is final and then disperse their payments wherever they're going to disperse them to. But with this case, like nothing is surprising me.
Yeah. All right. They did call her and refused to come, said her mom was sick. Oh, yeah. This is with Susan Logan. They were talking about that person. Okay. Let's see.
Oh, no. Let me say this. If I have appropriately subpoenaed a witness and they are not present, judge, issue a bench warrant. Let's get them here.
So why didn't they issue a bench warrant for that woman?
They didn't. Apparently, nobody asked for the bench warrant.
I wonder why.
Yeah, I would ask for a bench warrant, especially if I thought she was important to my case.
Okay, this is a historical case in history. Kells will go down in history.
Yeah.
All right. Couldn't his team question expose the parents and their part they played in the setup?
Yeah, that's why I said his defense in New York, I was really disappointed in it because they could have called so many people with information that would have been helpful for his defense, and they didn't.
Wow. Okay. Wendell says, could the judge in the 2002 trial be called as to testify why he dismissed the case back then? It was a jury.
No. One, you're not going to be able to call a judge to the stand only under certain circumstances. So, yeah.
Okay. Daddy Lola said, I think Kim Fox's real reason for wanting to dismiss the case is because too much was exposed in the two federal cases, and when unnoticed to the public, it wouldn't be that way in the state because it'll be televised. Well, TV. It'll be on TV.
So I think, like I said, it's just, I think at the state level, he would win again. He would win again.
Yeah, I believe so too. Question: can RSK be released on bail while waiting appeal trial after dismissal?
Technically, yes. She's not going to give him a appeal bond. It's not going to happen. They wouldn't even give him a regular bond. So no.
But technically, he could get one.
Technically, yeah, they have appeal bonds while your case is on appeal. Yeah, they do.
Wow.
But I know he wouldn't get one.
Wow. Okay, what about the Mann Act being used in New York appeal?
So no, I think that's also a great so I think his biggest points on appeal in New York are the RICO case and the Mann Act. Those are his two biggest points. And then his other points are just kind of small and ancillary to his bigger points. So I think in appeals, in appeal briefs, you have certain page limits and character limits and so on and so forth. So you have to kind of like put your best foot forward. And then, of course, ask for oral arguments.
Okay. What is your thoughts about prosecuting reaching out to Jim for his book before filing charges?
This is the thing. It's just, again, they want information that's going to help their storyline. His information helped their storyline. That's just what it is. If it would have been something that hurt their storyline, they would have buried that so deep in discovery that they would have probably overlooked it, because they don't want any information or to interview anyone who will disrupt their chances of getting their conviction.
Wow. Okay, what is your best guess on how long before he walks free?
So if he wins both appeals, let's be clear, the appeals process is slow. Because like I said, you can ask for all these extensions. And then once you get your extensions, then it's like, okay, are we going to have oral arguments? And when is the appeals court going to rule? So we may be like at 2-3 years before we even get in a ruling on his appeal.
Okay. So how come, what's the name, he was able to get his so quick?
Who?
Weinstein.
Oh, so one thing that the appeals courts do, they always say there's no time limit on our rulings. There's no time. We get the case once they have everything. They rule when they're ready. I had a case where I appealed a detention hearing, and they say they're supposed to be expedited rulings. They took like 3 months to give me my ruling.
Wow. So can you explain why age of consent was not argued enough in the cases? Because many don't know that age of consent varies state by state. Would this have made a difference in his cases?
Yes. And this goes back to, like I said, his defense. I was just so disappointed in it, because the age of consent does vary by state. But not only that, the age of consent changes. It can change. So let's just say they're arguing in 2000 that this young lady was 16 and had sex with him. Well, the thing is, and what you do as a lawyer is you say, okay, what is the age of consent there now? And then you go back and get the historical data to see what was the age of consent back then. Because ages of consent back in the day were very, very low.
Very low. It was very low. Yep. Yep. And back then, a lot of people married people that was young. It was
exactly.
Yeah.
Thanks.
I knew that was gonna come up. I knew that one was gonna come up. Oh my God. Okay. Can he sue Lifetime and Gayle King?
Not Gayle King, because he agreed to go on the show. Like, he agreed to go on that. He didn't have to go on the lady show. Lifetime, possibly, because again, the documentary was very irresponsible because it only presented information that supported what they wanted to portray, when in fact there were so many things that were not true, or to not bring up that, hey, these ladies had been paid and that they had changed their stories. They just presented their story. They didn't present the fact that, I changed my story 5 times. Like, if we're going to tell the story, tell the entire story.
Yeah. She answered this question already. It varies about the appeal approval and the denying. It takes anywhere from 2 to 3 years, you said, right?
Yeah.
Okay. So Lifetime, he can sue No, he can't sue Lifetime. Or can he?
He could. He could.
Okay. Okay. And of course, she's not going to give him an appeal bond. Okay, we already talked about that. Ruby isn't her first federal case. Okay, Okay, we didn't answer that one because we don't know what happened to the guard. I was trying to see any more questions. All right, here's another one. It says, can he sue the attorneys for giving him... Can he sue the attorney for giving him bad advice? His attorney advised him to sit with Gayle and help to set up this interview.
Yeah, he actually could.
Seriously? I laugh and they can't. Okay.
So do you guys watch the lady from the Real Housewives of New York, Bethany Frankel? When she got divorced from her last husband, she ended up suing her lawyers because the lawyers did her prenup. But what they left something out, which was a time frame, like if they broke up or separated, for him to move out. And they didn't include that. And of course, she paid them a lot of money for this prenup. And so she goes through hell trying to get this man at her house. And what did she do? She turned around and sued the lawyers.
Oh, wow. Black Beauty, I did miss your question. I don't know where I lost it. I lost your question. Could you ask for it again? Okay. Do you feel that there should be a statute of limitation of sex crimes? Why or why not?
Yeah, I think there should be a statute of limitations actually on most crimes, because the thing is, let's just say you want to bring something up from 10 years ago or however many years ago, an extended period of time, there is an inability for that person to prepare a proper defense. If you're alleging something that happened 10 years ago or 5 years ago, in that time frame, I have moved, I have, redecorated my home, I have done all these types of things. So I can't, if you're saying, well, we did it on this couch, in my living room at my home in, New York, I have no way of disproving that because I have since moved on with my life. These allegations should have come a lot sooner, so that I could prepare a proper defense.
Absolutely. Have you ever used a jury consultant?
All the time. So I use a jury consultant sometimes. Most of the time, people hire me as their jury consultant.
So you're excellent at picking out juries then, huh?
Yeah. So a lot of people, so we call it's voir dire or voir dire in Texas. That's the process of jury selection. A lot goes into that. And in the federal system, you only get, in most cases, the judge gives you a very, very short time frame to pick your jury. a very short time frame. So going in, a lot of things that I like to do is to say, okay, judge, we're going to get a short amount of time, and a short amount of time for jury selection. Like, I've had a judge give me 20 minutes for jury selection on a federal case. Mm-hmm. And they felt like they were being generous. So you have to like get to it. So there are a lot of things that you can do and that I like to do, which is like a jury questionnaire. If I only got 20 minutes or 30 minutes, hey, judge, since we already know who's going to be on the pool, can we send them a jury questionnaire? That way I can ask them certain questions before and have my answers before the actual trial.
Mm-hmm. Okay. I think I'm missing because these questions are not popping up. Okay, here it says here, there was a motion to overturn the Chicago federal case for the counts he was found guilty. However, there was evidence that someone lied during testimony, and if the judge overturns, it could speed up New York.
Nope.
All right, that's a no question. Kells appeared on Gayle King show, whereas he was to be paid for the interviews, but he didn't receive a dime. With this being said, can't he sue her?
So I don't know if there was an agreement for him to get paid, then yeah, that's breached the contract. But the Gayle King interview just should have never happened. I don't know who advised him that should have happened.
Yeah. The entire case was many hearsays. How can the government bring a case to court based on hearsay, social media, rather than documented police reports?
I mean, the thing is, because they have the ability to do it. Even if you have police reports, I have police reports where people lied. So, like I said,
yes, they do.
Yeah, they had a story and they were like, hey, who is going to testify to support our theory of this case? Yeah. Screw everything else.
Question. Herpes, all these female claim to have contracted because there are strains. Can the defense request to see if they are matched?
That would be a complete uphill battle because the court is not necessarily in a position to force a witness for testing. That's one thing. And the second thing is you have to protect these people's rights because this person is not on trial. He is.
But if they saying he gave it to him, then why you get what I'm saying?
Yeah. So then, because like keep in mind, you have a hard time getting medical records in cases. Like you have to get an order to get someone's medical records. So then you almost are on a fishing expedition because all right, you want this person's medical records. Well, they may not have gone to the doctor since X, Y, and Z amount of time. And, are the records still available? So on and so forth. So that's what you get into. And then you have to get deeper into their personal business to say, okay, well, what type of testing did the lab do? So it goes very, very deep. And I think in that situation, like the witnesses just would have been outraged. Yeah, because that would have been very invasive.
Yeah. Okay. Can generational Section 8 be revoked if Kelly is set free?
Oh, that is hope. She said generational Section 8.
That's what they said. It's generational.
Oh my gosh. So no, they probably wouldn't, because it's not like they're going to come back and say, you know what? It didn't work. We're going to take no, they wouldn't do that.
Okay. Why don't they make the age of consent the same age all over the country to just do away with this confusion?
Yeah, right. So the states hold the power, the ability to do certain things, and then the federal government has the ability to do other things. And so unless the federal government comes out and says what the legal age consent is, it's up to the states.
But don't the federal have a legal age of consent?
No, it's going to go by the state where the person is.
Oh, okay. Okay. All right. Tasha K takes credit for putting RK in jail. Why do you think she was never called on trial since she assisted in Homeland Security?
Yeah, I don't think she should be taking credit for that. So I just don't. Yeah, she shouldn't be taking credit for putting him in jail. There were so many other people involved to say that she did that. No.
Oh, Lord, this is this crazy question here. Can RK get paid for his music shaking leg? Also, one of the victims was dancing on Instagram.
Oh, you're talking about from them making it a sound on TikTok. So that goes to whoever has the royalties for that.
Oh,
If
okay.
they're using it and making the payment out for it, it goes to whoever has the royalties for that song.
Oh, so he's not going to get anything from it, right?
If he has his royalties from it, because keep in mind, like people make a song, a sound. Not only what happens is there people see like a spike in sales from that. So it's like who owns the royalties for that song?
Yeah, because it's a whole bunch of people doing that dance out there.
I know. One of the other girls, she sent me a video of his old attorney dancing to the song.
I'm sorry too. What's your thought on that?
I thought it was hilarious. That's the first thing. Second, like you didn't have anything better to do, and like what? Like you thought this was the trend to jump on. Like you thought this was the trend because I think like when he got found guilty, she wasn't even there. Like this wasn't the trend for you to jump on.
You just be telling it like T.I. is, don't you?
Like
you don't play, do you?
Like, ma'am, like this was not the time.
Okay. So are you saying that people can say someone gave them STD without having proof they actually contracted for STD, and when? If they test negative for herpes, how can they say he exposed them to it?
Yeah. So only way, like in civil cases, because I think the lady Faith Johnson sued him. Like in those, the standard is different. So let's just say it's like in Texas, it's the preponderance of evidence. So she has to prove her case. So she would have to bring her lab or whatever it is to show that she has it. And then he brings his evidence. Versus in a criminal case, the defendant does not have to present any evidence. He would just have to attack what they're saying. So let's just say if he did not have herpes and he had a lab report showing that he did not have herpes, then it would have been his duty to bring that to court to say, you all may have it, but guess what? I don't. You got it from someone else. But in a civil case, both sides get to ask the other side questions. Both sides get to request records from the other side.
Okay, she asks questions. She says, please ask, can Kim be considered as part of the corruption because she works in the SA office in 2008, but then she campaigned as a DA,
No, because a lot of time prosecutors start out as assistant prosecutors and then run for the head office.
Yeah. Muting him and stopping his funds, is there anything they can do about that?
No, because they aren't muting him. They aren't stopping his funds. This man has a viral TikTok sound. They aren't muting this man. And as a matter of fact, I think what's so crazy is people, like when it first came out with muting him and so on and so forth, and some of the streaming apps said they wouldn't do the paid promotion of his music. They didn't say they were going to stop playing it. They said they're going to stop promoting it, like doing the paid spots for it. So people, like a lot of advocates, felt like that was a win. And I'm like, nah, it kind of isn't. Because I remember, like, I heard his music more on my streaming once I went to the trial than I had ever heard it before.
Okay. Muting. Okay, we did that. Do you think the doctor testifying that R. Kelly tested negative for herpes but gave him medication anyway based on symptom he described over the phone and them using it and saying it is?
Oh, I know he's talking about. No, that's not actually what happened. I was there when the doctor testified. So what happened is the doctor said like he never tested R. Kelly for herpes. Because back then you just went based on what the symptoms were. And he kept having these symptoms recurring. And so that's how he got to the conclusion that he had herpes. And plus, R. Kelly was responsive to the medication.
But he did say he tested him and the culture came back negative. He did say that?
So what they
he
were
didn't
saying,
do the blood.
Yeah, because the testing methods had changed. So he never gave him the current testing methods.
Mm-hmm. All right. Can Robert sue all the celebrities for calling him a P word and when he wasn't proven to be one by a professional doctor that examined him?
No.
Okay. No.
That'd be him just wasting money.
Yep. No. All right. I think we had that 10 o'clock mark time, and I know it was 10 o'clock over here for me, 9 o'clock over there for you.
Yes.
One last question, and let's see who's gonna get the last question. Okay, here's last question from Sweet One. She said, "Can he sue YouTube for illegally taking down his channel?"
No, because you don't have a right to a YouTube channel. No one does. It's a private. It's a private company. You don't have a right to a YouTube channel. If Sylvia has 5 million viewers and take her channel down, she can sue them to try to get it back. But there's no absolute right for him or anyone else to have a YouTube channel.
Yeah. Okay. One more question. Can she explain why so many twists and turns in this particular case?
Because it is a goat rodeo. If I've ever seen one, it is a complete goat rodeo. And I think that the government just hopped on the train after the documentary to see what they could get to give some type of justice to these young ladies. And they hopped on the train and should have hopped off of it once they found out about a lot of the false statements from these young ladies, and they just kept going with it. And I think that he has a really good chance on appeal if it's done right.
So LaTanya wants to know, so you saying his lawyer in New York messed him up?
If she's talking about that lady, yeah. I don't even think it was beyond messing him up. It was bad. It was bad.
It was bad. All right. Thank you, Temani. That's enough with the questions. But as always, you are the bomb, and I like the fact that you give your open, honest question. Oh, they said black girl magic.
Thank you.
Okay, somebody said thank you so much. We all can rest now. I do have one more question. In your honest opinion about everything and the way everything's going around, do you think he will be totally restored after this?
Totally restored, no, because he can't be. In this situation, the situation that he's in, people don't realize the toll that criminal charges takes on a person physically. Mm-hmm. Let's just say he wins all of the appeals. He wins, hypothetically. Physically, his body has changed due to the amount of stress that he's incurred, but not only the financial blow that he will have incurred through all of this. So to say, oh, he'll be completely restored, no. The money that he's probably lost is astronomical. And not only that, you still will have people saying, okay, well, you did it. You just got off.
Mm-hmm. Mm-hmm. Just like they do with Bill Cosby.
Yeah. Well, his situation was a little different, but yeah.
Mm-hmm. Yeah. Well, thank you again, Temani. You rock. I tell you, you are the bomb, and thank you for your time as usual. And I apologize with the network and issues I had earlier. So I am so grateful for you being here again, and hopefully you'll come back.
Of course, I'll come back, little lady.
All right, guys. Say thank you to Temani, y'all. So you have any last thoughts before we close out?
Yeah. So on TikTok, I have this series called "The American Justice System is a Scam." I think if you guys watch it, I think I'm on tomorrow. I'll probably do number 9.
I watched some of it.
Yeah. So it talks about.
I watched the snitches one. I watched the snitches and stitches. I watched that one.
Yes, but it like actually brings up a lot of, like, the series is bringing up a lot of things that people don't know about the legal system. And like I said, how people, you think you're innocent until you're proven guilty. No, you're guilty until you're proven innocent.
Isn't that a sad situation? And especially if you're a person of color, it's worse.
Oh, it definitely is. And I think that's like my main reason, because like if you don't know certain things, you don't know the law or like how things work, then the legal system, the authorities are able to take advantage of you even more.
Wow. What's your TikTok name? They want to know.
Temani Adams. I'm not creative by any means. Everything is Temani Adams. I am not creative.
Temani Adams, y'all. Go follow her on her TikTok, right? TikTok.
Yes.
But I saw yours on IG. That's where I saw the clip.
Yeah, so like some of them I'll take them from TikTok and put them on IG.
Oh, well, Kane wants one more question. He says, can Robert sue Tasha K?
No, he can't sue Tasha K. I think the only remedy in that situation is that person from the BOP getting fired. That's the remedy.
They retired. Remember, they retired. They didn't get a chance to get fired.
So, or like him suing the BOP for breach of his information.
But he can't sue Tasha K for putting all that craziness out from the beginning.
So I just remember the thing about his messages. So I don't know what else was involved. I just know about the thing with his messages. But I mean, either way, I think it's definitely a reach, more than a reach, for her to take credit for placing him in jail.
Yeah, it's sad. But again, thank you so much. I appreciate your time, and definitely I will be asking you to come back once I get the brief of the appeal brief.
It's gonna be long. It's gonna be long.
It's gonna be very long. How many pages do they know? How many pages do it normally be? Thousands of pages?
No, not 1,000 pages, but they should have exhibits with them, and then of course you can ask to exceed the page limit. So,
will that be on Pacers? Will I be able to see it on Pacers?
Yeah.
Okay. All right. So, they have a date to have it done by, I think, the 17th of January. That's what the extension they asked for.
And then the government will respond, and then the government may ask for extensions, and so that's why I said it takes a while. It takes a while.
Okay. All right. And so, okay, what is the process? They do the brief, right? And then the government do their part, and then it comes back.
No, so you file your brief, the government responds, you can ask to reply to the government's response, and then the court cannot give you approval to do that. Then once everything is submitted, the appeals court reviews everything. They may ask for oral arguments, meaning R. Kelly's lawyers or the government may ask for oral arguments. In this case, I think they definitely should. They have oral arguments, which is where the attorneys go to the appeals court in person, and the appeals court is able to ask them questions. And then the judges make their decision.
Okay. And you cannot add any new evidence at all, right? You just got to use what's already preserved, right?
Yes. But again, under Rule 33, the Rule 33 motion for new trial based on new evidence, that's always that always comes into play in this situation, because you can do that up to 3 years after conviction.
Okay. So because of Rule 33 is already put in place right now, they can bring new evidence into the appeal process.
No. So in Rule 33, let's just say
because she denied the Rule 33 for New York.
No, you can do it more. There's more than one under Rule 33. There's a motion for new trial based on new evidence and something else. I don't want to slide over and get my code book, but it's 2 of them in there. The motion for new trial based on new evidence, you have 3 years. So if they get some new evidence within this 3 years, they can file another motion for new trial.
And that will go back to Judge Donnelly?
Yep.
Oh, I didn't know that. Okay. I got you. Okay. I understand now. But that's even though they put in for the appeal.
So she could, yeah, you can still do that. She may say, I'm going to stay this or put this on hold until the appeal court rules. But yeah.
Okay. That's something. Thank you for that. I didn't know that. God, thank you. Thank you so much for that information. All right. We're going to have to go because I'll have you on here until 12 midnight 9. We got to go to bed. But thank you again, Temani. I thank you so much. And guys, show your appreciation. Do the claps. Let's see the clapping hands. All right. Thanks, Temani. Have a good one. Okay.
You too. Have a good one.
All right. Bye-bye. All right, guys. Thank you, everybody, for being in your best behavior. I only had to block one person. But you guys, thank you. Have a good night. Bye-bye.